Pleadings and Motions. The initial pleading of a lawsuit filed by plaintiff, which begins an action and gives notice to opposing parties, is a complaint. The requirements is that complaints in federal court must contain 1, a statement of jurisdiction. So this can be short and plain statement of grounds upon which the court jurisdiction depends or why a court has subject matter jurisdiction. 2, statement of the claim. So this can be a short and plain statement of plaintiff's claim showing entitlement of relief, which must have plausibility pleading standard, which means the complaint must contain sufficient factual matter to state a claim that is plausible on its face. Allegations are acceptable as true, but conclusory allegations are ignored. Plausibility means factual content that allows the court to draw the reasonable inference that defendant is liable. Plausibility is more than possibility, but less than probability. So judges are encouraged to use their judicial experience and common sense. And 3, demand for judgment. So it must describe a relief sought, such as monetary damages or injunction. Then there's the answer, which is a response to the complaint in which defendant states the defenses to each claim, asserts and admits or denies each count on plaintiff's complaint. Defenses can be pleaded in the alternative. So for example, in breach of a contract claim, defendant can deny contract existed, but also answer that if a contract did exist, defendant performed under the contract. So then there's timing. It must be filed within 21 days of service of process or 14 days after a ruling on a Rule 12 motion. Requirements are that the answer must 1, respond to allegations of the complaint. Available responses are A, that they admit allegations, B, deny allegations. Failure to deny can constitute admission on any issue except damages, and lack sufficient information to admit or deny allegation. 2, raise affirmative defenses. Certain claims are waived if not explicitly pleaded in the answer. These may include contributory negligence, claim preclusion, statute of frauds, fraud, statute of limitations, self-defense, res judicata. Affirmative defenses are typically waived if not pleaded in the answer. Counterclaims. Defendant's claim against plaintiff may be required in defendant's answer or may be brought separately. So if it is required in defendant's answer, it is compulsory, and if it's brought separately, it's permissive. Then there's the Rule 12 motion. Defendant may attack the validity of plaintiff's complaint through a Rule 12 motion. Rule 12 defenses include lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, insufficiency of process, insufficiency of service of process, failure to state a claim, or failure to join a necessary party. So waiver. If these defenses are waived, if not included in the defendant's Rule 12 motions, provided they were available, Rule 12B defenses may be raised by a motion or an answer. Must be filed before an answer if responsive to a pleading is allowed. Motion for a more definitive statement. Rule 12E. If complaint is so vague or ambiguous that defendant cannot reasonably prepare a response, defendant may move for a more definitive statement from plaintiff. Motion to strike. Rule 12F. Defendant may move to strike from the complaint, or court may strike on its own any redundant, immaterial, impertinent, or scandalous material. Motion for judgment on the pleadings. Rule 12C. Plaintiff or defendant may move for judgment on the pleadings when the complaint plus answer reveal that one party must win. For example, defendant's answer admits all allegations in plaintiff's complaint. Plaintiff must win. Counterclaim. An offensive claim, either compulsory or permissive, raised by defendant against plaintiff, which may be pleaded in defensive answer to complaint. Jurisdictional requirement. Defendant must ensure the court has jurisdiction to hear any counterclaim. Note, compulsory counterclaims will almost always have supplemental jurisdiction. Compulsory counterclaim. Same transaction or occurrence. So a claim by a defendant against a plaintiff that arises from the same transaction or occurrence as one of the plaintiff's claims. This is required in an answer. Must be filed in defendant's answer or it will be waived. Defendant cannot assert it in a separate action at a later time. Permissive counterclaim. Different transaction or occurrence. Claim by defendant against plaintiff that does not arise from the same transaction or occurrence as any of plaintiff's claims. Not required in answer. May be filed with defendant's answer to plaintiff's complaint, but does not have to be. It can be asserted in a separate action filed by defendant. Crossclaim. Offensive claims asserted by a co-party. So a plaintiff sues defendant 1 and defendant 2. Defendant 1 may assert a cross-claim against defendant 2. Requirements is that the same transaction or occurrence, the cross-claims must arise from the same transaction or occurrence as the underlying action. Never compulsory, unlike counterclaims stemming from the same transaction or occurrence. Jurisdiction. Must have an independent basis for subject matter jurisdiction. Cross-claims will almost always satisfy supplemental jurisdiction requirements because they must arise from the same transaction or occurrence. Amending pleadings. Parties may amend their pleadings once as a matter of course. Additional amendments may be granted with consent of other parties or court permission, such as an amendment without right. Amendment as a matter of course may occur either A, within 21 days after service, or B, if a pleading is one which requires a response within 21 days of service of the responsive pleading or pre-answer motion. Rule 12 motion. An example is if defendant answers plaintiff's complaint, plaintiff has 21 days from service of the answer to amend the complaint. Party has 14 days or time remaining on initial 21-day deadline, whichever is longer, to respond to amended pleading. Amendment without right. Party may only amend with either A, a written consent of the adverse party, or B, leave of court's permission sought by motion. Leave will be granted freely when justice requires lenient standard. Courts look to 1, length of and reason for movement's delay, 2, potential prejudice to parties, and 3, futility of amendment. Amending pleadings, relation back. The relation back doctrine applies when a party amends a pleading and adds a new claim or defendant after the statute of limitations has run. The effect is, if allowed to relate back, The amended pleading will be treated as if it was filed when the original pleading was filed. Requirements for a new claim: amendments will relate back if the new claim concerns the same conduct, transaction, or occurrence as the original pleading. If the new claim is based on the same general set of facts as the original pleading. New or substituted defendant: amendment will relate back if 1. Amendment concerns the same conduct, transaction, or occurrence as original pleading, and 2. Within 90 days of filing of the original pleading, and the new defendant knew or received notice of action, and the new defendant knew or should have known that, but for a mistake, she would have been named originally. This applies when plaintiff sued the wrong defendant first, but the right defendant was aware of the mistake. Rule 11, certification and sanctions. Rule 11 requires the attorney or pro se party to sign all pleadings, written motions, and other papers. Certification. Signature acts as certified that to the best of the signer's knowledge, after all reasonable inquiry taken, 1. Filing is not an improper purpose, so like harassment or delay. 2. Non-frivolous legal contentions made are warranted by law. And 3. Factual contentions have evidentiary support. Factual contentions that are likely to have evidentiary support also suffice, but must be specifically so identified. Sanctions. Court may issue sanctions for violations either on the court's own initiative or an opponent party's motion. Court may not impose monetary sanctions on represented parties for frivolous legal contentions. Sanctions on attorneys are okay. Safe harbor. Rule 11 motion is served but may not be filed with the court for 21 days, creating a safe harbor. Party may withdraw the offending document or otherwise remedy the problem. If not remedied or withdrawn, motion can be filed. The judge need not provide safe harbor. Hearing required. Court must give attorney or party a chance to be heard before imposing sanctions. Rules discourage monetary sanctions by urging non-monetary sanctions and by creating a default rule that sanctions are payable to the court rather than the movement.